6 years of 80-hour weeks at Houston's most prestigious environmental law firm. Never lost a major case. Saved clients over $200 million in EPA fines. Had a perfect track record until the morning I was set to close the biggest environmental settlement in Texas history. That's when I got fired by a 31-year-old kid who thought groundwater contamination could be solved through collaborative dialogue and replaced with his college roommate who'd never set foot in a Texas courtroom. My name's Alex Torres, I'm 38, and up until that Tuesday morning, I thought competence mattered more than connections. Turns out I was wrong about that, but I was right about everything else. And 6 months later, I'm looking at the empty Caldwell & Associates building from my corner office window, watching them hang a bankruptcy auction sign in the lobby. Let me tell you exactly how we got from point A to point B, because this story's got everything. Incompetent rich kids, a $60 million lawsuit going down in flames, and the most satisfying kind of justice you can imagine. I've been practicing environmental law in Houston for 15 years now. Started right out of law school, worked my way up the hard way. No family connections, no trust fund, just a guy who grew up in a 2-bedroom apartment with parents who cleaned office buildings for a living. Worked nights stocking shelves to pay for law school, lived on ramen and coffee for 3 years, graduated with debt that took me 8 years to pay off. The thing about environmental law is it's not glamorous. You're not on TV, you're not making headlines, you're just trying to keep companies from getting buried under federal regulations that change faster than most lawyers can read them. But I was good at it, really good. In 6 years at Caldwell & Associates, I'd won 34 cases and lost 7. My clients trusted me because when the EPA comes knocking with a potential $50 million fine, you want the lawyer who knows the Texas Environmental Code like other people know their own phone numbers. And I was lonely as hell, if I'm being honest. Divorced 2 years ago because Sarah got tired of me working weekends and missing dinners and choosing client emergencies over family vacations. She wasn't wrong. I'd chosen work over everything else for so long that when she left, I barely noticed the difference. Just me and my case files and my morning runs and the satisfaction of being the best at something that mattered. The morning it all went sideways started like every other morning for the past 6 years. In the office by 7, coffee already cooling in my cup, reviewing files for Riverside Chemical Industries versus the state of Texas. This was the big one, a $60 million environmental cleanup lawsuit that I'd been living and breathing for 2 years. Riverside had a groundwater contamination issue at their Beaumont facility, and the state was claiming they'd been illegally dumping industrial solvents since 2015. But they hadn't. I'd spent 18 months and probably 500 hours proving that the contamination came from an abandoned petrochemical plant upstream that had been leaching toxins into the aquifer since the 1970s. I had soil samples going back 40 years, groundwater flow studies that would make a geologist weep, historical industrial records I'd dug out of county archives. It was bulletproof. We were maybe 10 days away from a settlement that would save Riverside $50 million and make me the most successful environmental attorney in Texas. I was reviewing the final settlement documents when my assistant buzzed me at 9:30. Bryce Caldwell wanted to see me immediately. Now, let me tell you about Bryce. 31 years old, law degree from some Ivy League school, and exactly 4 months of experience working at his daddy's firm. Before that, he'd spent 2 years in Europe finding himself and posting Instagram stories from Tuscany wine tours. His LinkedIn profile talked about bringing innovative disruption to traditional legal paradigms, which should have been my first red flag. Richard Caldwell, the founder, had semi-retired to Arizona and handed the firm over to his son like it was a family barbecue recipe instead of a 35-year legal practice with 42 employees and millions in annual revenue. I walked into Bryce's corner office, the same office that used to belong to a partner with 25 years of trial experience, and barely recognized it. Gone were the law books and case files. Now it looked like a tech startup, standing desk, motivational posters about thinking outside the box, and one of those ridiculous putting greens that people install when they have more money than sense. "Alex, have a seat." He didn't look up from his phone. Kid was probably checking crypto prices or planning his next European adventure. "What's up, Bryce? We need to discuss your role here moving forward." Still scrolling. "The firm's evolving. We're looking at new approaches, fresh perspectives, innovative solutions." I knew where this was headed, but I had to ask. "Is there an issue with the Riverside case? Because we're 10 days from settlement and it's going to be the biggest environmental win in firm history." That's actually what I wanted to talk about. He finally put the phone down and looked at me with the kind of confidence that only comes from never having been truly tested by life. "I'm making some changes to case assignments. Noah Bentley is going to take over Riverside. Noah Bentley. His college roommate from back east, hired 3 weeks ago straight from some white shoe corporate firm in Boston. Nice enough guy, probably brilliant with mergers and acquisitions, but he knew about as much about Texas environmental law as I knew about performing surgery. Bryce, with all due respect, Noah doesn't have any environmental litigation experience. He's never tried a case in Texas, doesn't know state regulations, hasn't reviewed any of the technical data. That's exactly why we need him. Fresh eyes, innovative thinking. You've been handling these cases the same way for 6 years. It's time for disruption. Disruption in environmental law, where one missed filing deadline can cost your client $50 million and a decade of EPA oversight. The Riverside case goes to trial in 6 weeks if we don't settle. The groundwater contamination involves 3 different aquifers, industrial discharge regulations dating back to 1974, and federal oversight from 2 different agencies. Noah doesn't know any of this. He'll figure it out. Besides, we're not looking to litigate. We're going to take a more collaborative approach with regulators. I stared at him. A collaborative approach with the Texas Commission on Environmental Quality, which had been trying to make an example out of Riverside for 2 years. What are you saying, Bryce? I'm saying today's your last day. Security will escort you out after you sign these papers. He slid a folder across the desk like he was handing me a restaurant menu. You're firing me. We're restructuring. Nothing personal. It's just business. Nothing personal. The guy was destroying 6 years of my professional life, handing my biggest case to someone who probably thought groundwater was something you found in your basement. And it was nothing personal. I opened the folder and started reading. Non-disclosure agreement, non-compete clause that would basically end my career in Texas, 3 months severance if I signed without making a fuss. This is pretty restrictive, Bryce. It's standard. Sign it and you get the severance. Don't sign it and you leave with nothing but whatever's in your desk drawer. I looked at him sitting there in his designer jeans and company polo shirt, probably wearing shoes that cost more than my parents made in a month back when I was growing up. Rich kid who'd never worked a real day in his life, never stayed up until 3 a.m. reading EPA compliance manuals, never had to choose between paying rent and taking the bar exam. I need to think about this. You have 1 hour to clean out your office. After that, security walks you out whether you've signed or not. So there I was, packing 6 years of my professional life into cardboard boxes while a security guard watched me like I might steal the staplers. My diplomas, my case files, my coffee mug that said "World's Most Adequate Lawyer," a joke gift from Sarah back when we still laughed together. But here's what they couldn't pack into those boxes. The relationships I'd built with 28 corporate clients who trusted me with their most expensive problems. The expertise I'd developed in Texas environmental regulations that took me 6 years to master. The reputation I'd earned for being the guy who could navigate EPA compliance without bankrupting your company. And here's what Bryce didn't understand about environmental law. It's not like corporate tax planning where you can figure it out as you go. When you're dealing with industrial discharge permits and federal penalties, the details matter. Miss one filing deadline, cite the wrong regulation, misunderstand one geological survey, and your client is looking at triple penalties and years of government oversight. I signed the papers, not because I was scared, but because I had a plan. That evening I was sitting in my empty apartment, and I mean empty. Sarah had taken most of the furniture when she moved out, drinking a beer and staring at my phone. The first call came at 6:15. Tommy Richardson, CEO of Richardson Industries. I'd saved his company from an $80 million EPA fine 3 years ago when they had an accidental discharge at their refinery. Alex, what the hell happened? I just got off the phone with Noah Bentley. I'm not with Caldwell anymore, Tommy. I figured that out when he asked me if we needed to worry about fish in our industrial water treatment system. Fish. In an industrial water treatment system that processes petroleum byproducts. I almost laughed, but Tommy sounded genuinely worried. What exactly did he say? He wanted to know about our environmental impact on local wildlife. Asked if we'd considered installing fish ladders in our discharge pipes. Tommy paused. Alex, fish ladders are for salmon migration around dams. We process oil refinery waste. I understand your concern, Tommy. My board meeting's Thursday. These people trust me to keep this company compliant and profitable. I can't have some kid from Boston learning environmental law on our dime. What are my options here? I'm bound by certain agreements right now, Tommy. But hypothetically, if an old friend wanted to grab coffee and discuss the current regulatory environment, just general information, nothing specific to ongoing cases, that might be possible. Coffee sounds good. Tomorrow morning work for you? By the end of the week, I'd had coffee with 8 former clients, and every single conversation went exactly the same way. How's the new representation working out? Well, he seems nice, but he asked if we could handle our EPA compliance through collaborative dialogue instead of confrontational legal strategies. Or he wondered if there was a way to get a friendly exemption from federal environmental regulations. These were sophisticated business people who'd been dealing with environmental law for decades. They knew the difference between competent counsel and someone who thought you could negotiate with federal statutes like they were corporate contracts. The call I'd been waiting for came Friday morning. Maria Santos from Santos and Webb LLP. I'd known Maria for 5 years. Tough, smart, built her practice from nothing into one of the most respected litigation firms in Texas. More successful than me, more experienced, and had never once made me feel like the working-class kid who didn't belong in the club. Alex, I heard what happened at Caldwell. News travels fast in legal circles. It does when it's spectacularly stupid news. Look, I'm going to cut right to the chase. We want to bring you on as a partner. Full equity, your own environmental division, complete autonomy on case management. Maria, I've got a non-compete agreement. I've had our attorneys review it. It's probably unenforceable in Texas, and even if it holds up, there are ways to work within it. The question is, are you interested in building something that can't be destroyed by someone's incompetent son? The way she said it, with just the right amount of disgust, told me everything I needed to know about how the legal community was viewing Bryce's leadership decisions. What did you have in mind? Santos, Webb, and Torres. Equal partnership, 40% equity split. You bring your environmental expertise and your client relationships. We provide infrastructure, litigation support, and most importantly, protection when Caldwell tries to sue us. Because they will. I'd be lying if I said I thought about it for more than 30 seconds. I'm in. The next 3 weeks were busy. Setting up the new practice, getting licensed with the state bar as a partnership, creating a professional website that didn't look like a tech startup's mission statement. I was careful not to violate my non-compete. No direct solicitation, no sharing of confidential information, no active recruitment of Caldwell clients. But I didn't need to recruit anyone. The clients came to me. Richardson Industries was first. Tommy called on a Monday morning and said they were requesting proposals from 3 different firms for ongoing environmental compliance work. Santos, Webb, and Torres was one of the firms they were considering. By Friday, we had a 5-year contract worth $2 million annually. Then Coastal Petrochemicals called. They'd been with Caldwell for 8 years, but they had some concerns about their new representation. Apparently, NOAA had suggested they could save money by handling routine EPA filings in-house instead of paying lawyers to do paperwork. EPA filings that, if done incorrectly, could result in fines of up to $50,000 per violation. We're not looking to change firms, their general counsel told me over lunch. We're just exploring our options in case our current representation doesn't work out. Within 2 weeks, they'd terminated their relationship with Caldwell and signed with us. By the end of the month, we'd signed 14 former Caldwell clients. Not because I'd solicited them, but because they'd experienced what happens when you replace competent environmental counsel with someone who thinks EPA regulations are just suggestions. And then the Riverside chemical case went to trial. I wasn't there, obviously, but in environmental law, court proceedings are public record. Filings, transcripts, expert witness reports, it's all available if you know where to look. What I saw was a complete disaster. NOAA had missed the deadline for filing expert witness disclosures. In environmental cases, expert witnesses are everything. You need geologists, chemical engineers, hydrologists who can explain groundwater contamination to a jury. Without expert witnesses, you're basically asking 12 people to take your word that underground water flows in certain directions. He'd cited federal regulations that had been superseded 3 years ago. Environmental law changes constantly. New EPA guidelines, updated water quality standards, revised permit requirements. Using outdated regulations is like showing up to court with a map from 1995. Worst of all, he'd submitted geological surveys for the wrong aquifer. The contamination at Riverside involved the Chiquet Aquifer, but NOAA had filed reports about the Evangeline Aquifer, which is 60 miles away. It was like claiming your client couldn't have robbed a bank in Houston because he was in Dallas that day, then providing an alibi for Austin. The opening statement made it into the legal newspapers. NOAA had argued that his client couldn't be responsible for groundwater contamination because groundwater flows underground where no one can see it, making it impossible to determine responsibility for any alleged contamination. The judge actually stopped the proceedings to ask if he was serious. Riverside Chemical lost everything. $60 million in cleanup costs, another $20 million in penalties, 10 years of EPA oversight, and a court-ordered environmental monitor that would cost them $5 million annually. The company that should have settled for $10 million was now looking at potential bankruptcy. The Houston Business Journal ran the story on their front page. Environmental case meltdown costs local company $80 million. They didn't mention Noah by name, but everyone in Houston's legal community knew exactly what had happened. That's when my phone started ringing constantly. Companies that had never been Caldwell clients were calling, asking if we were accepting new business. Word travels fast when a major environmental case goes that catastrophically wrong. General counsels were wondering what other cases Noah Bentley was handling, and whether they wanted their companies represented by someone who didn't understand the difference between an aquifer and an oil reservoir. Within 6 weeks, 24 of my former clients had terminated their relationships with Caldwell and Associates and signed with Santos, Webb, and Torres. They didn't do it because I asked them to. They did it because they'd watched a $60 million settlement turn into an $80 million disaster, and they weren't interested in finding out what Noah might do to their legal matters. That's when Caldwell and Associates filed their lawsuit against us. They claimed I'd violated my non-compete agreement, stolen trade secrets, and engaged in tortious interference with business relationships. They filed in federal court, demanded an emergency injunction to stop me from practicing environmental law, and asked for damages that would have bankrupted our firm 3 times over. The hearing was scheduled for a Thursday morning. Federal Judge Patricia Murphy, who'd been on the bench for 12 years and had a reputation for not tolerating frivolous litigation or incompetent lawyering. Caldwell brought a team of 8 lawyers. We brought Maria and our litigation specialist. Their lead counsel stood up and delivered a 20-minute presentation about how I'd orchestrated a systematic campaign to destroy Caldwell and Associates by stealing their clients through unfair competition and misuse of confidential information. Judge Murphy let him finish, then asked a simple question. Counsel, do you have any evidence that Mr. Torres directly solicited these clients? Your Honor, the pattern speaks for itself. 24 clients don't leave a law firm coincidentally. That's not what I asked. Do you have evidence of direct solicitation? Phone records, emails, witness testimony of Mr. Torres contacting these companies first? Long pause. Your Honor, the circumstantial evidence strongly suggests I'll take that as a no. Judge Murphy looked at our table. Ms. Santos, your response? Maria stood up calmly. Your Honor, we've provided documentation showing that every single client contacted Mr. Torres first. We have phone records, email timestamps, and signed affidavits from corporate executives. Not one of these companies was contacted by our firm before they reached out to us. The judge spent about 10 minutes reviewing our exhibits. Mr. Torres, please stand. I stood up, trying to look more confident than I felt. You worked at Caldwell and Associates for 6 years? Yes, Your Honor. And you were terminated without cause to make room for an attorney with no environmental law experience? That's correct, Your Honor. And this inexperienced attorney subsequently lost a major case that you had been managing successfully for 2 years? Yes, Your Honor. The Riverside Chemical case resulted in an $80 million judgment against the client. Judge Murphy looked directly at Bryce, who'd been sitting in the front row trying to look important while his lawyers did the talking. Mr. Caldwell, let me explain something to you about how the law works. Clients have the right to choose their legal representation. When you fire experienced attorneys and replace them with inexperienced ones, clients have the right to seek more competent counsel. That's not tortious interference. That's the free market. She turned back to the Caldwell legal team. Your motion for injunctive relief is denied. Mr. Torres is free to practice law and accept clients who approach him voluntarily. Then she leaned forward, and her voice got that tone that judges use when they're about to end someone's career. And let me add something for the record. I've been on this bench for 12 years, and I've seen hundreds of environmental cases. The Riverside Chemical matter was one of the most incompetent pieces of legal representation I've ever witnessed. If you want to keep clients, I'd suggest you hire attorneys who actually know what they're doing instead of filing frivolous lawsuits against the people who do. The courtroom was dead silent. Bryce looked like someone had just told him his trust fund had evaporated. Case dismissed. Caldwell and Associates will pay all defendants' legal fees. The story made every legal publication in Texas. Judge sanctions environmental firm for incompetent representation. This time they did mention Noah by name, and they quoted Judge Murphy's comments extensively. 2 days later, my phone rang at 8 in the morning. Richard Caldwell himself calling from Arizona. Alex, we need to talk. His voice sounded older than I remembered, tired in a way that went beyond physical exhaustion. I'm not sure there's anything to discuss, Mr. Caldwell. There's plenty to discuss. My son destroyed everything I spent 35 years building, and you're the only one who might be able to help salvage what's left. I could hear the desperation in his voice, and for a moment I almost felt sorry for him. Almost. I'm not interested in salvaging anything, Mr. Caldwell. I'm interested in building my own practice with people who understand that competence matters. Name your price. Full partnership, your own division, complete control over environmental cases. Hell, I'll fire Bryce if that's what it takes. It's too late for that. It's never too late to fix a mistake. Some mistakes don't get fixed, Mr. Caldwell. Your son didn't just fire me. He replaced me with someone who turned a $60 million win into an $80 million disaster. He destroyed client relationships that took 6 years to build. He made your firm a laughingstock in the Houston legal community. That doesn't get undone with job offers. Richard was quiet for a long time. When he spoke again, his voice was barely above a whisper. What would it take to stop this exodus? What do you want? I don't want anything from you, Mr. Caldwell. Your clients aren't leaving because of anything I'm doing. They're leaving because your son put their legal matters in the hands of someone who doesn't know the first thing about environmental law. That's not my fault, and it's not something I can fix. You could tell them to stay. Why would I do that? So they can watch Noah turn their next case into another disaster? These are sophisticated business people, Mr. Caldwell. They're not leaving to hurt your feelings. They're leaving because they don't trust your firm to protect their interests. He hung up without saying goodbye. 3 months later, Caldwell and Associates filed for bankruptcy. They'd lost 36 clients, couldn't make payroll, and were facing malpractice suits from Riverside Chemical and 4 other companies whose cases Noah had mishandled. The firm that Richard Caldwell had spent 35 years building was liquidated in a bankruptcy auction that lasted 2 hours. Bryce is selling insurance now, working at his uncle's agency in the suburbs. According to the Legal Gossip Network, he's actually pretty good at it. Turns out he's better at convincing people to buy things they might not need than he was at managing things that actually mattered. Noah went back to Boston with his environmental law career effectively over. Word travels fast in legal circles, and Judge Murphy's comments about incompetent representation made it into legal databases that firms search when they're considering new hires. As for me, I'm sitting in my corner office at Santos, Webb, and Torres looking out at downtown Houston. We've got 53 clients now, 18 lawyers, and a reputation for actually knowing what we're doing. Not bad for a practice that started because some rich kid thought environmental law could be disrupted like a tech company. Yesterday, I got a LinkedIn message from Bryce. He wanted to know if we were hiring, said he'd learned a lot from his experience and was ready to start over with a better understanding of legal practice. I didn't respond. Some lessons you have to learn the hard way, and some consequences you have to live with permanently. The thing about environmental law, hell, the thing about any kind of law, is that it's not about innovation or disruption or fresh perspectives. It's about competence. It's about knowing the regulations, understanding the science, and keeping your clients out of trouble. When you fire the person who actually knows how to do the job and replace them with someone who thinks expertise is optional, you don't get innovation. You get bankruptcy. Bryce Caldwell learned that being the boss's son doesn't make you qualified to run anything more complicated than a lemonade stand. His father learned that 35 years of reputation can be destroyed in 6 months if you hand your life's work over to someone who doesn't understand its value. The Caldwell and Associates building is still empty 6 months later. There's a for lease sign in the lobby where the family portraits used to hang. Every time I look at it, I remember what my constitutional law professor used to say during our first week of law school. The law doesn't care about your daddy's money or your family connections. It only cares whether you know what you're doing. Turns out he was right about that too.